I'm now joined by legal expert Khumisi Kganare. Khumisi, a very good afternoon to you. Thanks very much for your time. Well, I mean, the main concern of the ANC when they filed this application, they said, was that voters will not be able to distinguish between itself and the MK party on the ballot box. But that's now a moot point, isn't it?
Not necessarily. I mean, the process would have to be exhausted to a point of really clarifying this issue, even for, contestations to come, if you may. The argument was thin, yes, but, there's still avenues they can still pursue. The big question for them is, are they likely to succeed if they are given this, leave to appeal? And my view is the chances are very slim going forward.
And what do you base that opinion on?
I mean, even in the, remember when we now go for appeal, we cannot introduce new evidence, we cannot introduce, new facts. You will have to ride on what you put across at the court of core, in this case being the High Court, which had this matter. And you look at the issues of confusing similarities, the ANC was very thin. Even before we got to the merits, there were issues of agency, there were issues of locus standi, there were issues of jurisdiction, which they could not, argue successfully, that court had to sit at that time on an urgent basis and resolve this issue. They couldn't, convincingly argue that that court had jurisdiction to hear this matter and not the electoral court. The issue of locus standi, that they do have the right as the ANC to, be there and fight this perceived or alleged infringement, and not the legacy projects entity. So just on what we have as facts and evidence, prospects seem very slim going forward.
Was it able to convince the court that, in fact, the symbols belong to it?
I would say to some extent, well, largely yes. And that's not where, the responsibility would stop. Remember, you have to show a lot of things, especially with registered rights, insofar as trademarks are concerned. It mainly concerns itself with the protection of registered trademarks, which we know in this case there is a mark that is registered under Class 41. Another thing is that, then you do get your protection immediately. And the right forum for that would be that of the High Court, where registration on its own is sufficient. But remember, there's also elements of passing off, which is a different route altogether, which is that of common law, and it concerns itself a lot with elements of goodwill, damages, and misrepresentations. And we know, at least to this point, that they could not successfully argue that.
And let's say for a second, I mean, on the Class 41, under which the trademark was registered, which the court said provides for education, training, entertainment, sporting, and cultural activities. And apparently, I mean, politics does not necessarily fall within that category.
Yeah, I mean, with NIST classifications, you would get, services or goods defined in a way that's mostly general. And when you file for protection, you would have to, along those lines, still explain your business case or your position that you are protecting and explain further beyond what you see in the needs classification insofar as your goods or services are concerned, but you must still toe the line of what the class talks about. So we know in this case that it was very difficult to then also try and capture politics under class 41, because even on the application or even the registration certificate when it comes out at the end, that was not mentioned in the certificate itself or even the application at the inception of this process.
And the court, of course, was also unable to make a finding on whether the MK's use of the mark was unauthorized.
Yes. Well, the MK argues that it may have not been permitted, but to say that it's unauthorized, it's also incorrect. And you'll remember that when you deal with these issues, you will also have to, define the market really. To say if we were to concern ourselves narrowly with the space, with the market, in which there are issues relating to this trademark, it would be, the political space. Even narrowly beyond that would be, voting, essentially. And when you look at the actual, now moving away from that logo that we know there's an arrangement with between the ANC and the legacy projects, now the actual ANC logo, side by side with the uMkhonto Sizwe Party logo, there is no, confusion just by looking at the two trademarks. And we know there's no registration insofar as, the brand name uMkhonto Sizwe is concerned. So those are the sort of things that the presiding officer would have to, deal with. And at this instance, it's really up to the ANC to convince, the High Court that a different court would get to a different conclusion should they be given, leave to appeal.
Well, we'll see what comes out of it. Khumisi, let me thank you very much for your time.